Hi, it's Roland Jones. This is another video in a series of videos, short videos on issues relating to preference and fraudulent conveyance defense. In this case, the question is whether payments were made in the ordinary course, and the trustee came up with an interesting argument. The defendant was a provider of restructuring consulting services, and Harney Management Partners provided these services pursuant to a retention agreement, and they were timely paid. The trustee argued here, how can this possibly be incurred? How can this possibly be a debt incurred in the ordinary course, since these were payments to pay for restructuring services? This is not normal for any business, not ordinary course to hire someone to possibly prepare for bankruptcy or consider that as an option, perhaps, and restructure debt. This was a situation where obviously the company was in some kind of trouble and was paying a consultant. So how could this be ordinary? It's not within the ordinary scope of what this company typically did. The defendant argued this was a service like any other service, and the debt was incurred at arm's length, with arm's length negotiation, and it was paid in the ordinary course. It doesn't matter that the transaction itself deviated from the scope of what the business of the debtor. This is the relevant code section. I'm just going to yellow out incurred, since that's really what we're looking at. We're looking at part of 547C2. Was this a payment of a debt incurred by the debtor in the ordinary course of business or financial affairs of the debtor? The trustee says, no, it's not. Wasn't ordinary. It's not its business to restructure, to be restructured or consider restructuring, and so it shouldn't be in the ordinary course. Court shot down the trustee's argument and found that the relationship that was in the ordinary course, and the debt was incurred in arm's length bargaining between the two parties during arm's length bargaining, and the debt was also paid in the ordinary course. So the takeaway here is as follows. A debt which results from an agreement entered at arm's length dealing can still be incurred in the ordinary course, even though you could argue that the transaction itself is not really typical of the scope or ordinary for the business. It doesn't matter. Courts are going to view this debt as being incurred in the ordinary course if the debt was incurred as a result of arm's length negotiation.